All right, welcome back, everyone, for another deep dive. And today we're going to be tackling, I think, a pretty unique legal process. And this one comes from Spain, and it's called Concurso de Acreedores.
Concurso de Acreedores. And you can think of it as kind of their version of bankruptcy proceedings. But we're going to dig a bit deeper into how it works, especially when it comes to contracts.
Okay.
And to guide us through this pretty complex topic, we've got some excellent materials from a law firm based in Almeria, Spain, called MCHM Abogados, and they specialize in this area of law. So
yeah, it's interesting how Concurso de Acreedores, it's not just about, shutting down a failing business.
right.
It's actually designed to give companies a chance to restructure and potentially recover while also considering the interests of the people they owe money to, so the creditors.
So it's not just a simple, win-lose situation.
Exactly.
It sounds like there's a lot of balancing involved there.
Absolutely.
Can you give me an example of how that plays out in practice? Sure. One of the key tools available in Concurso de Acreedores is the ability to either suspend or even completely resolve existing contracts a company might have. So think of it as hitting a pause button or sometimes even a start button on certain agreements.
Okay, but wouldn't that cause a lot of disruption, especially for the people or businesses on the other side of those contracts?
Yeah, that's a valid concern, and that's where the Spanish legal principle of vigencia de los contratos comes into play.
Yeah.
This principle really emphasizes the importance of keeping contracts in force whenever possible, even when a company is facing financial difficulties.
So even if a company is struggling, they're still encouraged to honor their agreements.
Right.
Why is that so important in the Spanish legal system?
Well, for one thing, it helps maintain a sense of stability and continuity for everyone involved.
Right.
Imagine the chaos if every single contract was automatically voided as soon as a company entered Concurso de Acreedores.
Yeah, I can see how that would create a ripple effect that could make things even worse for the company and its creditors.
Yeah, exactly.
But what about situations where a contract is actually harmful to the company's chances of recovery?
Yeah, that's where the option of contract resolution comes in.
Okay.
If a contract is simply not beneficial for the company trying to restructure, they can request to have it terminated entirely. And to ensure fairness, this often involves financial compensation for the other party involved.
So it's not just about letting the company off the hook.
Right.
There's a process for determining if any financial fallout needs to be addressed as a result of breaking these agreements.
Exactly. Those compensations, also known as indemnities, then become part of the overall debt that needs to be managed during the Concurso de Acreedores process.
That makes sense.
Yeah.
But wouldn't some companies be tempted to just enter Concurso de Acreedores as a way to renegotiate all their contracts and get a better deal?
That's a great question, and it brings up an important point about Concurso de Acreedores.
Okay.
It's not a get-out-of-jail-free card.
Right.
And it's certainly not a process you enter into lightly. There are safeguards in place to prevent abuse, and judges are very careful to ensure that it's used appropriately.
It sounds like Concurso de Acreedores is a much more nuanced process than simply declaring bankruptcy.
It definitely is, and that's what we're here to explore today, to understand how this system works in practice and what it means for both the struggling company and the people they do business with.
So let's dive a little deeper, shall we? We've talked about contract suspension and resolution, but I'm curious about how those decisions are actually made.
Sure.
Who gets to decide which contracts are essential and which ones can be put on hold or terminated?
Well, that's where the role of the administrator comes in.
Administrator.
This is a professional appointed by the court to oversee the entire Concurso de Acreedores process.
So this administrator, they sound like they have a pretty crucial role to play in this whole process.
Yeah, absolutely they do. They're essentially responsible for taking a close look at the company's financial situation, analyzing their existing contracts, and making recommendations to the court about which ones should be suspended or resolved or left untouched.
I imagine that requires a lot of expertise and judgment. It must be a bit like being a financial detective trying to piece together the puzzle of a company's finances and figure out the best way forward.
That's a great analogy. You're right. It's a complex job.
Yeah.
The administrator has to consider the interests of both the company and its creditors, all while working within the framework of Spanish law.
We talked earlier about this principle of vigencia de los contratos, which favors keeping contracts in force. But how does that actually work in practice? If a company is struggling to pay its bills, how can they be expected to simply carry on with all their existing agreements?
Well, it's not always about maintaining contracts exactly as they were originally written. Sometimes adjustments need to be made to reflect the company's new financial reality. For example, payment schedules might be renegotiated, delivery terms might be altered, or other modifications might be made to make the contract more manageable for the struggling company.
So even if a contract isn't suspended or resolved, it might still need to be tweaked a bit to make it work within the context of concurso de acreedores.
Precisely. It's about finding practical solutions that allow the company to continue operating and hopefully eventually to recover.
Earlier, you mentioned that companies can sometimes receive financial compensation when contracts are terminated during concurso de acreedores. Can you elaborate on that a bit? I'm curious to understand how that works in practice.
Sure. Let's imagine a scenario where a company has a long-term lease for a large office space, but due to their financial troubles, they simply can't afford to stay there anymore. During concurso de acreedores, they might request to have this lease resolved, meaning they want to get out of the contract.
But wouldn't that leave the landlord in a difficult position? They would suddenly be losing a tenant and a stream of income they were relying on.
Exactly, and that's where the compensation comes in. The court might decide that the company needs to pay the landlord a certain amount of money to compensate for the lost rent they would have received if the lease had continued as planned.
So it's not just about letting the company walk away from a bad deal without any consequences. There's a mechanism in place to ensure that the other party isn't unfairly disadvantaged.
That's right. It's about finding a balance between giving the company the flexibility it needs to restructure and protecting the legitimate interests of its creditors.
Okay, that makes sense. Now, let's say a company is going through concurso de acreedores, and they have a contract that's not exactly essential, but it's also not causing them any major problems. What happens to those kinds of contracts?
Good question. Those contracts might just continue as usual with perhaps some minor adjustments as needed. The focus in concurso de acreedores is really on those key contracts that are either essential to the company's survival or are creating a significant financial burden.
So it's not a case of throwing out all the contracts and starting from scratch. It's about prioritizing and making strategic decisions about which agreements need to be addressed and how.
Exactly. And it's important to remember that the goal of concurso de acreedores isn't to punish companies or to shut them down. It's about creating a structured process that gives them a chance to reorganize, address their debts, and hopefully emerge stronger on the other side.
I can see how this would be particularly relevant in today's economic climate where businesses are facing all sorts of challenges and uncertainties.
It definitely is, and it's a good reminder that even in the face of financial difficulties, there are legal mechanisms in place that can help businesses find a path forward.
This has been incredibly insightful, but before we move on, I have one more question about the role of the administrator. We've talked about their responsibility to analyze contracts and make recommendations, but what other powers do they have in this process?
Well, their powers are quite extensive, actually. For instance, they have the ability to sell off company assets to generate funds to pay creditors. They can negotiate with creditors to reach debt restructuring agreements. And they can even propose a plan for the company's reorganization, outlining how they intend to become profitable again.
Wow, it sounds like the administrator has a lot on their plate.
Yeah.
I guess that's why it's so important to have someone with a deep understanding of both business and law overseeing this process.
Absolutely. And that brings us back to MCHM Abogados. They have a team of lawyers who specialize in concurso de acreedores and can provide expert guidance to companies navigating this complex process.
Yeah, their insights have been invaluable for our deep dive today. We've covered a lot of ground from the legal framework of concurso de acreedores to the intricacies of contract management. But I think it's important to step back for a moment and remember the human side of all of this.
I agree. Behind all the legal and financial jargon, we're talking about real people and their livelihoods. Think about the employees of a company facing concurso de acreedores. They're likely feeling a lot of uncertainty about their jobs, their futures, and then there are the business owners themselves who may be watching years of hard work and dedication hanging in the balance.
It's a good reminder that even though we're discussing legal processes, the stakes are high for everyone involved.
Definitely, and that's why having a legal team that understands the complexities of concurso de acreedores, but also approaches these situations with sensitivity and empathy is so important.
Speaking of practical considerations, what advice would you give to a company that finds itself facing the possibility of concurso de acreedores?
Yeah.
What are some key things they should keep in mind?
Well, first and foremost, don't panic. It's a difficult situation, but it's not the end of the road. The key is to take action quickly and decisively.
And seeking expert legal counsel would be high on the list, I imagine.
Absolutely. As we've discussed, concurso de acreedores is a very nuanced process. And having experienced lawyers like those at MCHM Abogados on your side can make all the difference. They can help you understand your options, develop a strategy, and navigate the legal complexities.
Besides seeking legal advice, are there any other proactive steps a company can take?
Communication is crucial. Be open and transparent with your creditors, your employees, and any other stakeholders. Explain the situation clearly and outline the steps you're taking to address it.
It sounds like building trust and maintaining open lines of communication is essential in a situation like this.
It absolutely is. And finally, be prepared for a long and challenging process. Concurso de acreedores is not a quick fix. It's a journey that requires patience, resilience, and a commitment to finding solutions.
It's a marathon, not a sprint, as they say.
Exactly. But with the right approach and the right support, it's a marathon that companies can not only finish, but can also use as an opportunity to emerge stronger and more resilient.
This has been such a fascinating and informative deep dive. I feel like I've gained a much deeper understanding of concurso de acreedores, not just the legal mechanics of it, but also the human impact and the potential for positive outcomes.
I'm glad to hear that. And remember, this is just a starting point if you're interested in exploring this topic further. There are many resources available, including the expertise of MCHM Abogados.
So if you find yourself facing a situation where concurso de acreedores is a possibility, remember to breathe. Seek expert advice and know that even in challenging times, there's always a path forward.
Thanks for joining us on this deep dive.
It's been a pleasure. Until next time.